Have you ever stopped to think about how a global rule, something countries agree on around a table in Geneva or New York, actually becomes a law that can be used in a court in, say, Manchester? It's a really fascinating puzzle, and when you start to unpack it, you see this constant push and pull between international agreements and a nation's own power. So let's dive in and figure it out.
So that's the big question, right? How does an international rule make the jump to become a UK law? You might think it's simple, but the answer is anything but. And the way the UK handles this actually reveals a core, fundamental principle about how its entire legal system is built.
And the answer is, well, it depends. Because in the UK, they've drawn a very clear line in the sand. There isn't just one way for international law to get in. There are two completely separate journeys, and the path the rule takes depends entirely on what kind of rule we're talking about.
Okay, let's break down these two types of international law. On one hand, you've got customary international law. Think of this as the unwritten rules of the road for nations. Things countries have been doing for so long that it's just accepted as law. On the other hand, you have treaties. These are the formal, written contracts signed between countries. And here's the absolute key. The UK treats these two categories in fundamentally different ways.
So let's explore the first route, what we're calling the automatic path. This is the one that applies to that customary, unwritten law.
The starting point here seems pretty simple, right? These unwritten, customary rules are generally considered to be part of the UK's own law of the land. This means, in theory, a British judge can look at an established international custom and apply it directly in a case. Sounds easy enough, but, you probably guessed it, there's a catch.
Turns out, even this automatic path has a couple of really important roadblocks. There are two critical conditions that have to be met before a customary rule can actually be used in a UK court.
And here are those limits. First, and this is a big one, the international rule cannot contradict a law, a statute, that's been passed by the UK Parliament. If Parliament has spoken, that's the end of the story. Their law wins. Second, if a UK court has already made a ruling about a specific customary rule, future courts are bound by that decision. They have to follow that precedent, even if the international understanding of the rule has evolved over time.
Okay, let's totally switch gears and look at our second path. This is the parliamentary path, and it's the one that all those formal, written agreements, the treaties, have to follow. And believe me, this journey is anything but automatic.
So this is probably the most crucial takeaway. Unlike those customary rules, treaties are not automatically part of UK law just because the government signs them. Signing a treaty is something the government does. But for that treaty to actually become the law of the land, something more has to happen.
This quote gets right to the heart of it. It says, if a treaty is going to cause any alteration of the existing domestic law, basically, if it changes the law for people inside the UK, then it requires legislative action. And legislative action means one thing and one thing only. Parliament has to get involved. So when does Parliament have to give its approval? Well, it's pretty much any time a treaty has a real-world impact inside the UK. If it's going to affect your rights as a citizen, cost the government money, or change existing laws, Parliament has to pass an act. A perfect example is the Human Rights Act of 1998. The government signed the European Convention on Human Rights, but those rights weren't enforceable in UK courts until Parliament passed that specific act to bring them into domestic law.
So we've got these two totally different paths, right? One is kind of automatic, but has some serious roadblocks, and the other requires a deliberate act from Parliament. Why? What is the fundamental principle that explains this whole setup? It really all comes down to a core idea about who holds the ultimate power in the United Kingdom.
And there it is, in just two words, parliamentary sovereignty. This is the bedrock constitutional principle that explains everything we've just talked about. It's the reason treaties are treated with so much caution.
So what does that really mean? It means that in the UK, the supreme, ultimate lawmaking authority is the elected parliament. The government on its own can't just go off and sign an international treaty that suddenly changes the rights of British citizens. It's a powerful protective mechanism to make sure that only the elected representatives of the people can actually change the laws that govern the people.
And all of this brings us to a final, really big question for today. We've seen how the UK system is designed to protect its own lawmaking power. But in our incredibly interconnected world, where we face huge global challenges that demand international cooperation, is this fierce protection of national sovereignty still the right balance? That's a debate at the very heart of the UK's relationship with the rest of the world.